Hello, this is Nancy Lemon. I'm the Legal Director for the Family Violence Appellate Project. Thank you for viewing our webinar. If you have any technical difficulties viewing this recorded webinar or would like a copy of the recording training slides, please email us at training@fvaplaw.org. If this recorded webinar is not accessible to you, please contact us at training@fvaplaw.org, and we will work with you to provide the material in an accessible format. MCLE credit is available for completing this webinar. For information on how to obtain MCLE credit, please visit www.fvaplaw.org/training. This training is Key California Family Law, Juvenile, Criminal, and U.S. Supreme Court decisions involving domestic violence from 2016. What is FVAP? Family Violence Appellate Project provides free appellate representation to low and moderate income survivors of domestic violence throughout California in cases involving restraining orders, child custody, and other domestic violence issues. We are a state bar recognized support center for legal aid providers working on family law cases. We are also a resource for California domestic violence agencies, specifically on family law issues. We're based in Oakland and we serve the entire state of California, and we have screened hundreds of requests for assistance since we started in June of 2012. We have a 77% success rate in prosecuting appeals, which is much higher than the average success rate of 21% for the state in general. And we have a 100% success rate when we defend appeals. So those are restraining orders where the person that's restrained is appealing and we're saying that the court did the correct thing. Our mission. Our state has many well-crafted statutes that were designed to protect survivors and their children. However, these laws are very underutilized. There's very few appellate decisions referring to them. So many courts are not aware of them, and neither are attorneys, and certainly unrepresented people are not. So part of our mission is to assist and protect individual survivors of domestic violence and their children. And another part of it is to build a body of published appellate decisions to guide attorneys and judges throughout California. And we've been pretty successful with that. One of the ways that we build this body of cases is through our case publication project. So most cases in California that are coming from the appellate courts are not published. One of the things that we do is screening all of these new family law and juvenile court decisions as they're coming from the appellate courts, and we identify those that we think merit publication, and then we request publication. We also, of course, usually request publication of our own cases if we have one, if the court does not indicate that it plans to publish the decision. So in 2016, our agency was involved in 6 published California cases involving family law and juvenile law, and 1 U.S. Supreme Court case. Out of those 6, in 3 of them we represented one of the parties. 1 was an amicus brief, and 3 were through our case publication project. In addition, in this slideshow, there are 2 other U.S. Supreme Court cases and 5 other significant cases from California courts involving domestic violence that we were not involved in. So that's 14 total cases that I will be discussing in this training. In terms of the content of the training, here's the table of contents. First, we'll talk about tribal courts and abusers. Then another federal case, which is about the prohibition on abusers possessing firearms. Then we'll look at several domestic violence restraining order cases, issuing them and renewing them. Then we'll look at custody cases and spousal support. 1 case on the right to a judge instead of a commissioner for your restraining order hearing. Then a couple of juvenile court cases, and finally 1 criminal case that involves domestic violence that might be relevant for family law practitioners. So starting with tribal courts, there are 2 cases here. They're both federal, and the questions presented in the first one is, may a tribal court assert jurisdiction in a civil suit over a non-tribal corporation whose employee allegedly sexually assaulted a minor tribal member, where that corporation operated on a reservation and had a contract with the tribe to be there. And in the second case, the question is, did the use of prior tribal court domestic violence convictions, where the defendant did not have the right to counsel, violate the Sixth Amendment when those convictions were used to support a third conviction for him being a habitual domestic violence offender under the federal statute? So the first case is called Dollar General versus Mississippi Band of Choctaw Indians, U.S. Supreme Court. Generally, tribes do not have jurisdiction over non-tribal members. But here, the Choctaw tribe entered into a contract with the Dollar General Corporation to operate a store on their reservation in Mississippi. Then there was a young tribal member, a boy, who was allegedly sexually assaulted by the store manager, who was a non-tribal member, during the job training program that was operated by the tribe. So this young person and his parents sued the manager and Dollar General in tribal court. Dollar General argued that the tribal court had no jurisdiction over them. However, the district court upheld the tribe's jurisdiction. So Dollar General appealed that, and the Fifth Circuit Court of Appeals affirmed. They said that tribes have inherent sovereignty since prior to the existence of this country, and that the sovereignty of tribes was not extinguished by the U.S., and it can be limited only by Congress. Our agency signed on to an amicus brief that was written by the National Indigenous Women's Resource Center, and it argued that there's a national crisis of domestic and sexual violence that is committed by non-Indians against Indian women. They also argued that there's a need for tribal court jurisdiction over these non-Indian perpetrators in order to sustain the tribe's self-governance. And they said that violence against Native women and children that's perpetrated by non-Indians on tribal lands imperils the tribes. It imperils their political integrity and their economic security and their health and welfare, because there is a great deal of unresolved and widespread trauma from these survivors. So it's a really big issue for tribes to be able to prosecute these perpetrators. The brief also argued that tribal tort law is a critical self-government solution to this crisis that's imposed by the unresolved trauma. The U.S. Supreme Court agreed and said that, well, actually, the U.S. Supreme Court, because we have only 8 justices right now, and the court was split 4-4, that meant that the Fifth Circuit decision stands. So tribes can assert civil jurisdiction over non-tribal members and corporations, at least in the Fifth Circuit, but probably in the other circuits. The second case involving tribal courts and abusers is a criminal case, U.S. versus Bryant. In that case, they also talked about the fact that Native American women experience the highest rates of domestic violence and sexual assault compared to any other group in this country, and they're often repeatedly assaulted or killed by the same offender. Because of that, Congress enacted a felony offense of domestic violence in Indian country by a habitual offender if there were 2 or more prior domestic violence convictions. However, under the Indian Civil Rights Act, defendants facing 1 year or less imprisonment, essentially a misdemeanor, do not have the right to appointed counsel. So this is different from the U.S. Constitutional right under the Sixth Amendment, the right to counsel for misdemeanors. It does not apply in tribal courts. In this case, Bryant had multiple prior domestic violence convictions in tribal court, and he had no appointed counsel because he was facing jail sentences of less than a year. He did, however, have appointed counsel when he got to federal court and when he was convicted later of being a habitual domestic violence offender. So he got convicted of that and appealed his conviction, and the Ninth Circuit reversed the use of his priors to support his conviction because they said that this use would have violated the Sixth Amendment if the case had been in state or federal court originally. However, the U.S. Supreme Court disagreed with the Ninth Circuit and held that convictions that are valid when they were entered retain valid status when they are invoked in subsequent proceedings. And they were unanimous that a felony offense of domestic violence in Indian country by a habitual offender, which included tribal court convictions as predicate offenses, does not violate the U.S. Constitutional Sixth Amendment right to counsel. So they sent it back to the Ninth Circuit, who affirmed the conviction. There's a third federal case that we'll talk about dealing with firearms, and the question presented there is, in applying the federal prohibition on convicted batterers possessing firearms under Title 18 of the U.S. Code, Section 922G9, can the underlying misdemeanor domestic violence conviction be for reckless conduct, or does this apply only to conduct that is knowing or intentional? The case is called Voisin versus U.S., comes out of Maine, and there were two different cases that were joined, Mr. Voisin's case and Mr. Armstrong's case, because they presented the same issue. In each case, these men pled guilty to misdemeanor assaults of their female partners, and the Maine state code section defines assault as intentionally, knowingly, or recklessly causing bodily injury or offensive physical contact with another person. 35 other U.S. jurisdictions have a similar definition, so it's about 2/3 of all the states define assault in this same way. After these men were convicted of assault, they were each convicted of violating this federal code section when law enforcement found that they had guns. So they appealed, and the Court of Appeal upheld their convictions, rejecting the argument that subsection G9 did not apply because, they argued, their prior convictions could have been based on reckless conduct. And the reason they made that argument is because the prior case law discussed only knowing conduct or intentional conduct. And it held that knowing or intentional acts equaled use of force, which triggered the gun ban. But they didn't discuss in these prior cases, what about reckless acts? So it went up to the Supreme Court, and the Supreme Court held that recklessness is a conscious disregard of substantial risk that conduct will cause harm to another. They stated that the act must be volitional, not accidental. And the High Court also noted that when subsection G9 was enacted, most states defined misdemeanor assault or battery to include reckless infliction of bodily harm, and they held or stated that Congress must have known this when it enacted that subsection. So for policy reasons, they stated, it's very important not to exclude these reckless acts because that would mean that the gun ban doesn't even apply in 35 jurisdictions, or 2/3 of the states. They held that a conviction in state court for reckless domestic violence, as opposed to knowing or intentional domestic violence, is sufficient to trigger the federal prohibition on convicted abusers possessing firearms. This actually doesn't affect us in California because our penal code definition of battery, section 242, says any willful and unlawful use of force or violence upon the person of another. So there's no mention of knowing, intentional, or reckless. Now we're going to move on to restraining orders, and there's two cases involving the issuance of initial restraining orders. One of them asks and answers the question, what is a dating relationship for purposes of the Domestic Violence Prevention Act? And the second one raises the question, if a wife testifies that she's afraid of the husband due to physical abuse in the past, but then they have sex after the temporary restraining order is issued, but before the hearing, is it an abuse of discretion for the trial court to issue a domestic violence restraining order protecting the wife? The first case is called Phillips versus Campbell. This comes from the 2nd District, which is around Los Angeles. In this case, the parties met through professional cycling. They were both bicyclists who actually made their living through races and so forth. They became friends. Mr. Campbell said he wanted to move forward in the relationship, and Ms. Phillips said she wanted to just be friends. So he texted her many times. He posted her personal information and photos on Facebook. He posted videos of her on YouTube. and he otherwise shared in very public ways the personal information about her. In his text, he called her a psycho-evil witch, a compulsive liar, said she had lied about him, and destroyed his life. She then requested a domestic violence restraining order, and in her request, she said that she had significant concerns about her well-being and safety because he had accused her of destroying his life, and he continues to become more and more angry. She said in her email to him, we built our relationship over many months, strengthening our love and respect for each other. She also said to him, we are not dating. And when she got to court, she said, we spent time together, we dined out, he stayed over at my place, we lay in bed together, we kissed and hugged, and Campbell sent me nude pictures of himself, but we're not dating. Mr. Campbell said to her, you led me on while dating someone else. To the court, he said that she was falling in love with him, but they were just best friends. They never went on a date. And the reason he sent these nude pictures is he was a nude model. He also told the court that his expression of love for her was platonic, and it was caring and concern for his best friend, not a girlfriend. So here's some family code sections that are applicable. 6211 defines domestic violence as abuse perpetrated against any of the following people, and subdivision C includes a person with whom the respondent is having or has had a dating or engagement relationship. We also have section 6210 in the Family Code, also in the Domestic Violence Prevention Act, and it defines dating relationships as meaning frequent, intimate associations that are primarily characterized by the expectation of affection or sexual involvement, independent of financial considerations. So not paid sex, but maybe having sex and or expectation of that, and frequent intimate associations. So the question is this abuse? And if so, is it a dating relationship? Should the court grant her request, Ms. Phillips' request, for a domestic violence restraining order under the Domestic Violence Prevention Act? And you can think right now, yes or no. What do you think? The trial court found that this was a dating relationship because it held that they did have frequent intimate associations, primarily characterized by the expectation of affection, despite the fact that both of them said they were not dating. And the trial court also found that Mr. Phillips had destroyed Ms. Campbell's peace. I'm sorry, Mr. Campbell had destroyed Ms. Phillips' peace and issued a 5-year domestic violence restraining order. Mr. Campbell then appealed. He argued that the restraining order was not appropriate because they weren't dating and his actions were protected under the First Amendment. So these actions would have been posting things to Facebook and YouTube. The appellate court upheld the issuance of the restraining order. They stated that the dating relationship here was a factual issue that the trial court decided based on all of the evidence, and that its finding that this was a dating relationship was based on substantial evidence. So that was sufficient. They also held that the First Amendment violation, alleged violation, was waived because it had not been raised at trial court and his speech was abusive. And abusive speech is not protected under the First Amendment. The case is particularly important because modern relationships in the 21st century often do not fit within traditional definitions of dating. And survivors of domestic abuse, like the one here, may not define their relationships in traditional terms, like as a boyfriend-girlfriend relationship. Our second case, involving restraining orders, is called Fregoso versus Hernandez. It's from the 4th District. So that's the San Diego, Orange County part of our state. In this case, the parties had been married for 5 years and they had a young daughter. The husband, Mr. Fregoso, filed for divorce and sole custody, and he alleged that the wife was violent to him. The wife, Ms. Hernandez, requested a temporary restraining order then, and she alleged that the husband was violent to her and to their daughter and said that she was afraid of him. At the hearing, the husband denied abusing the wife or the daughter, but the wife testified that the husband had recently grabbed her arm and bruised it, He threw her on the daughter's bed so hard that it broke. He squeezed her face into the mattress, this is the wife's face, so that she could not breathe. The wife also said that the husband threatened her regarding his godfather, who he said was a drug trafficker, and that he hit their daughter with a belt repeatedly. The wife said she did not call the police because she was afraid of the husband. She conceded that they had had sex after the temporary restraining order issued, and she explained that this was part of a pattern in their relationship, where the husband would be violent, then he would seek forgiveness with gifts, and then they would have sex. When the husband testified, he said that the wife was lying, that she was trying to gain an advantage in the custody matter, and she was angry that he had filed for divorce. That's why she had made up these false allegations. However, the court believed the wife and granted a 1-year restraining order, and the appellate court affirmed. They said there was substantial evidence that supported the issuance of the domestic violence restraining order. We see that's the same standard that was in the Phillips v. Campbell case, substantial evidence. The husband then appealed, and he argued on appeal that consensual sex after the temporary restraining order had been issued, but before the hearing, obviously showed that the wife did not fear him, and nor did she need protection from him. The appellate court disagreed with the husband, upholding the issuing of the restraining order and citing the wife's testimony regarding the physical abuse that the husband had inflicted on the wife and the child. And the court also stated that the wife also testified that the parties' post-TRO sex was part of their 6-year repeated cycle of violence, with gifts, forgiveness, and then sex, and then repeated acts of violence. This is a very important case because it's the first one we've seen in California where the appellate courts talk about the cycle of violence, which we see a lot in domestic violence cases. The court also is explaining that what might appear to be behavior by a survivor of abuse that shows she's not afraid of the abuser, in fact, could be, and in this case is, part of this cycle, and thus she could still be afraid, even if she had had sex with him. Now we're going to move on to renewing restraining orders, and we have one case here, and a cute little cartoon by one of our summer interns from the summer of 2016. The restraining order has just expired, says the cat, and the mouse is calling 911. So in this case, there's many different questions presented. One is the father's alleged abuse of the party's children, that was during visitation, relevant to the mother's request to renew the restraining order? Also, is it reversible error for the trial court to refuse to include the children as protected parties in the restraining order? Third, in order to renew this restraining order, does the petitioner, here the mother, have to prove that the restrained party violated it? And finally, in order to renew, does the petitioner have to prove physical abuse while the order was in effect? This case is called De La Luz Perez versus Torres Hernandez. It's from the 1st District, which is San Francisco area and the East Bay. In this case, the mother, Ms. Perez, and the father, Mr. Torres Hernandez, were in a relationship starting in 2000. The mother already had one son, and then she and the father had 2 girls together. In 2010, 10 years into their relationship, the mother filed for a domestic violence restraining order. She claimed many instances of physical and emotional abuse by the father. These included threats to kill her, threats to take the children. He called hundreds of times a day. He broke into her home in the middle of the night. He hit her many times, and he called her names and other types of abuse. She asked that the restraining order keep the father away from the girls as well as from her. The court granted the 3-year restraining order and gave her sole physical custody with visitation for the dad, and he was ordered not to harass, molest, etc. the mother. However, this restraining order did not include a stay-away order from the mother, and it did not include a no-contact order, either from the mother or the children. So it was just don't harass, molest, and so forth her. The following year, she sought to modify this restraining order to protect all 3 children, her son by the first relationship and the 2 daughters. During the visits that these children were having with this father, the father was physically abusing them. He was using his hands, shoes, a belt, and he left bruises and welts sometimes. He was actually arrested for abusing the younger daughter. The mother testified at the restraining order renewal hearing that the father had not hit these children before the restraining order was issued. So this started after they separated, when he was having visitation. The family court suspended visits with the younger daughter, the one for whom dad was now being charged with child abuse, and the court ordered that the visits with the older daughter be supervised. Of course, there was actually no reason why the son needed to see this father, because he was not adopted by the father. The court ordered the father not to contact the mother, which probably should have happened with the first restraining order. But anyway, now it was happening in 2011. In 2013, the mother went back and she requested another renewal. This time she wanted a permanent restraining order. And this is the only time you can get a permanent restraining order, is after you are renewing, when you are renewing a restraining order that's been issued after a hearing. Those are either 5 years or permanent, according to the statute. At this hearing, she said that the father was calling and texting her from other numbers, not his own, that he was pushing her to stop going to court to seek custody and child support, that he threatened her and called her crazy. She also said that the child abuse charges, in terms of the younger daughter, were dropped because that daughter was too young to testify. And she said that after that point, the father feels he can break the law. She testified that she had a lot of fear of him and fear that he would physically abuse the children again. She said that he had violated the restraining order many times with no consequences and that she felt helpless. The court stated that any alleged child abuse by the father was not relevant to the renewal of the restraining order because the abuse had to be towards the mother, not the children, and it refused to renew the restraining order. It said the abuse against the children was irrelevant to the mother's fear, and that the harassing calls and texts from the father to the mother were not, quote, abuse. That the trial court stated that abuse must be, quote, violence or the infliction of violence on an individual, end quote. Therefore, it was insufficient evidence of a reasonable belief of continued abuse to support another domestic violence restraining order. This is wrong, and the appellate court reversed. It cited Section 6320, part of the Domestic Violence Prevention Act, which defines abuse to include harassing and telephoning and disturbing the peace of another party. So any of those is sufficient. It also cited Section 6345, which talks about renewal of orders after hearing, and it said that renewal is allowed without a showing of any further abuse since the issuance of the original order. That's right there in the statute. The appellate court also said that the alleged abuse of the children by the father during the visitation was relevant to renewal and also relevant to whether they should be included in the restraining order. It then cited Section 6203, which includes fear of injury to another as a grounds for issuing a restraining order. And it stated that the evidence that the father struck the daughter was relevant to show that he disturbed the peace of the mother. The court stated that renewal of this restraining order does not require proof of abuse during the time period since the order was issued. Again, that's in the statute and in some case law prior to this one. And it also stated that the father's continued calls and texts were relevant to show the mother's reasonable apprehension of future abuse. There is a concurring opinion by Justice John Streeter, the former state bar president, which included studies about the overlap between domestic violence and child maltreatment. These were conducted by several different researchers. One is Dean Jeff Edelson, who's at the School of Social Welfare at UC Berkeley, also by Meisner and Korn, and a third study by Hart and Klein. And Streeter stated that to evaluate both of Ms. de la Luz Perez's requests for relief, one was for renewal and the other one is for modification to add the children. It is important to recognize that the interests of the children are, as a practical matter, bound up with the interests of their mother under the relevant statutory standard. We thought this was really useful language. We're very happy that we got this published, as well as winning it, because it's the first time we've seen an appellate decision that's citing social science data about this overlap and this recognition also that the interests of the children and the mother are bound up together. Now we're going to move on to some custody cases. We have 3 of those this year. But first, a little background. Back in 2014, the Family Violence Appellate Project won 2 very key appeals. One was Christina L. versus Chauncey B., and the other one was Fahota versus Fahota. They had similar facts, including evidence of extensive physical abuse by the father toward the mother presented at the trial. And in spite of that, in each case, well, in the first case, the court awarded joint physical and joint legal custody to Chauncey B. And in the second case, that court awarded joint legal custody to Mr. Fahota. In both cases, they were reversed on appeal. And this was because the trial courts had failed to comply with Family Code Section 3044, which states that there's no custody to an abuser unless the presumption against custody to abusers has been rebutted. So in these 3 cases, they present 3 different questions. In the first one, where a domestic violence restraining order has been granted, and then the court awards sole custody to the protected party, in this case the mother, and a 50-50 timeshare with the father, but calls that visitation, is this reversible error? In the second case, the question presented is where another state has issued a domestic violence restraining order, and then the California court awards custody to the restrained party, in this case the father, based on California preference for frequent and continuing contact with each parent. Is this reversible error? And in the third case, this one gets very technical. In a child custody proceeding where there is no court reporter and the allegedly abused mother is not represented, so she doesn't request a statement of decision, and then the trial court changes custody from her to the father, may the appellate court imply that the trial court made all the necessary findings to support its decision? So the first case under custody is Celia S. versus Hugo H., 4th District, so around Orange County and San Diego. In this case, the parties had a long relationship but were not married, and they had 2 children together. There were several acts of domestic violence by the father toward the mother. They separated in 2014, and they stipulated to a 50-50 timeshare with alternate weeks, and the court entered that stipulation as a court order. The next year, 2015, the mother invited the father to have dinner with her and the children, and then he assaulted her in front of them. The police arrested the father after the son told them that he saw the assault. The mother filed for a domestic violence restraining order and requested sole custody, and the father testified at the hearing that he did not hit the mother. However, a social worker testified that the children did see domestic violence in the past. The father presented no evidence that custody of the 2 children to him would be in the children's best interest. So the trial court found that the father had committed domestic violence against the mother, and it held that Family Code Section 3044 applied, the rebuttable presumption against custody to abusers. It then issued a 1-year domestic violence restraining order, so that's also a finding of domestic violence, even if it hadn't specifically said that it found that 3044 applied. In this restraining order, it said that the father must stay away from the mother and children except during visitation. The mother was awarded sole legal and physical custody. The father was awarded what the court called visitation. It was a 50-50 timeshare, a week at a time, just as they had had before. They continued their existing arrangement, except that no longer could the father pick up the children at the mother's residence. The court also ordered the father to complete a 1-year batterers program, the 52-week program that we see under the penal code, and then the court was going to hold a review hearing about custody. And of course, that is one of the rebuttal factors under 3044B. Has this person successfully completed a 52-week batterers program? And if so, then that could be part of rebutting the presumption against that person having some type of custody. The appellate court reversed and remanded. It held that Section 3020 of the Family Code prioritizes children's health, safety, and welfare over frequent and continuing contact with each parent after separation. So we have basically two different goals in California in terms of custody. One is always to prioritize health, safety, and welfare of children. The other one is to always prioritize frequent and continuing contact with each parent. So subdivision C of this section, 3020, talks about what to do if there's a conflict between those two different goals. And it states very clearly that one should prioritize health, safety, and welfare. The court also cited section 3044, which, as we know, establishes a mandatory presumption against any type of custody, whether that's sole or joint, whether it's legal or physical, to a parent who has perpetrated domestic violence in the last 5 years. And the appellate court cited Code Section 3011, Subdivision E. This requires courts to state their reason for awarding any type of custody to a parent who has allegedly perpetrated domestic violence. And the court has to state this reason in writing or on the record. Here, the father did not even attempt to rebut the presumption under 3044, and the appellate court stated that the trial court may not circumvent 3044 by characterizing its order as visitation, when it was really joint physical custody. And it also stated that the nature of any order is based on its legal effect, not the label the court attaches. It cited sections 30, 31, and 3100, which govern visitation in DV cases. On remand, it said that the court shall consider ordering supervised visits, or even suspending visits or denying visitation altogether. In our second custody case for today, we have Ellis versus Lyons from the 2nd District Court of Appeal. This started in 2002 when the father filed a paternity action. In 2009, the parents stipulated a joint custody of their 1-year-old daughter, so this must be a different child. This daughter was living mostly with her mother in Massachusetts and visiting her father in California. And then, 5 years later, while the daughter was visiting the father in California, there was a physical altercation between this father and his brother-in-law, and this was in front of the daughter. The daughter called 911 on her cell phone. The father took the phone away and told the 911 dispatcher that there was no need to come. He threatened to slap his daughter, though he didn't actually hit or slap her. The daughter later called her mother in Massachusetts, told her about all this, and said that she was really scared. The mother applied for a temporary restraining order in California to protect her daughter, but when she was told she had to give notice to the father, she did not proceed because she was worried that that would endanger the daughter, who was still staying with the father for several weeks. So then the mother got a temporary restraining order in Massachusetts, where the mother lived, based on that altercation. The father had an attorney who was present representing him, and he was told by that court that he was not allowed to contact his daughter anymore. The daughter testified, and while she was testifying, she was shaking and crying about her fear of her father. And then the mother took the Massachusetts order and asked the California court to modify custody to sole legal and physical custody to the mother and supervised visits with the father in Massachusetts. The California court held a hearing on that and said no. They said the Massachusetts order was improperly issued. They denied the request to change custody. That court said it did not believe that the daughter feared her father or was in danger. It also stressed the need for frequent and continuing contact with the father, citing Section 3040 of the Family Code, which talks about that same concept, frequent and continuing contact. And that California trial court made no reference at all to Section 3044 or the rebuttal factors in 3044, such as, has the person completed a batterers program, etc., even though the mother's attorney actually had raised this concern in 3044 at the trial or hearing. This was reversed on appeal. The appellate court stated that the Massachusetts restraining order against the father, this is the restraining order after hearing there, gave rise to California's Family Code Section 3044 presumption. that custody to him would be detrimental to the daughter's best interests. It also stated that it was immaterial that the daughter was not actually injured, and said that she was in reasonable apprehension of imminent serious bodily injury. It also stated that relying at all on the preference for frequent and continuing contact with the non-custodial parent, here the father, in order to rebut Section 3044, quote, infects the custody decision with reversible error, even when the trial court also relied on other factors to rebut the presumption. This is very significant language because we see very frequently that courts will rely in part on this preference for frequent and continuing contact, and essentially that goes against what Section 3044 is all about, and our legislative intent to protect children from being in the custody of abusers. Our third custody case for today is AG versus CS. This is from the 3rd District Court of Appeal, which is Sacramento and north from there. In this case, the father filed a petition for sole legal and physical custody of the party's 3 boys. The mother then filed a request for a restraining order, and that was denied. The court found that there had been no abuse. She actually had alleged that, among other things, that he had tried to strangle her. But the court found that it did not actually believe her. The court also adopted a prior agreement between the parties, which gave sole custody to the father, and the mother was to see the boys on the weekends. The mother did not have an attorney, and the father did. So right there, statistically, she was very likely to lose, and she did. So then she appealed, and we represented her. There was no court reporter at either the domestic violence restraining order hearing or at the custody trial. Sacramento no longer provides court reporters in family court, and she didn't realize that she really should have hired somebody to do that. Plus, she didn't have very much money. Because there was no court reporter, there's no transcript, and therefore the parties had to create something called a settled statement for appeal, which is authorized by the California Rules of Court in lieu of a transcript. Neither party requested a statement of decision. So when we were creating the settled statement, we met with the client many times over the phone, and we helped her try to remember what had happened at each of these hearings, the restraining order hearing and at the custody trial. Then we wrote it all down and gave it to opposing counsel, and they made their own modifications, and eventually we went to the trial court, and it made its own modifications, and then we had a settled statement that we used for the appeal. And the fact that neither party requested a statement of decision was also very key here. Of course, the mother had no idea what that was, and the father's attorney didn't request one. So it would have been a good idea for them to do that, especially without a transcript. So the appellate court upheld what the trial court had done, switching custody from mom to dad. One of the reasons that it gave is that the use of a settled statement in lieu of a transcript does not negate the doctrine of implied findings, where the parties waived the statement of decision. And we argued on appeal that the settled statement was sufficient to replace both the transcript and a statement of decision, but the appellate court stated that if there's a statement of decision that's given in a child custody action, that would have provided the Court of Appeal with the reasoning of the trial court. That was the problem. They didn't have its reasoning on the disputed issues, and that the statement of decision is a touchstone to determine whether or not the trial court's decision is supported by the facts and the law. They said that's different from a settled statement, which merely states, you know, mother argued this, father argued this, here's what the court ruled, but not reasoning. The appellate court also stated that generally under the doctrine of implied findings, when the parties waive a statement of decision expressly or by not requesting one or not requesting one on time, because you have to request it in a very timely manner, appellate courts must presume that the trial court made all the factual findings that are necessary to support the judgment for which there is substantial evidence. So in other words, there's an assumption that the trial court did the right thing. And in order to overcome that it's very helpful to have a statement of decision to show exactly what the trial court was thinking and on what it relied. Here we argued that the settled statement did show the trial court's errors, so the doctrine of implied findings did not apply. But the appellate court disagreed with us. It stated that the settled statement used by the parties does not contain an express statement by the trial court, that it complied with the procedures required for adopting a statement of decision, and that the settled statement serves as the court's statement of decision. In other words, it could have been equivalent to a statement of decision, except the trial court didn't say that. So the doctrine of implied findings applied, and it upheld the trial court. The appellate court also said that under this doctrine of implied findings, there was evidence here that supported an implied finding that the court did properly consider the father's documented history of DUIs, of which he had, I believe there were 3, when making this child custody determination. And that's relevant because Family Code 3011 requires the court to consider the party's history of substance abuse, not just child abuse and partner abuse. The appellate court also stated that the settled statement adequately set forth the trial court's reasons for granting the father's sole custody of the children, even in spite of these allegations of the father's alcohol abuse, which is, as I said, a factor under 3011. It also stated that the trial court did adequately consider the nature and amount of contact the children had with both parents when awarding custody of children to the father. One of the things that the trial court had found was that the mother had a history of, quote, running away with the children to her family and to shelters, and to not telling the father where they were, and it held that against her, instead of seeing this as the mother protecting herself and the children from abuse. So we argued that that should have been in her favor, but in fact the trial court held that against her and used that to help support its decision to change custody. The trial court also, according to the appellate court, the trial court could also rely in part on its own observation that the mother, quote, acted in a very abnormal manner and may be depressed when it was awarding custody of children to the father. And we argued at the oral argument that she was probably very afraid of this father because she was alone, she had no attorney, and she could see that things were going against her at the trial court, and that it's not up to the trial court to diagnose somebody as being depressed or not. And finally, the appellate court said that the mother was not entitled to a mid-trial continuance, where she asked if she could continue the whole matter so that she could go get an attorney. And the trial court said no, it was too late, and the appellate court agreed with that. So that was a case that we lost. One of the things that happened in that case was opposing counsel's hearsay objections to the mother's evidence of domestic violence were sustained. And the mother didn't know that there were exceptions to the hearsay rule. For example, excited utterance, which is what her neighbor was describing. Oh yes, wife came over, mother came over yelling that he had strangled her. But that neighbor was not allowed to testify because it was hearsay and mom didn't know of a hearsay exception. The mom did realize that she needed an attorney and asked for a continuance, but that was denied. So one of the things that this case raises is the issue of unrepresented parties being overwhelmed by opposing counsel, and thus whether there should be a right to appointed counsel when a parent may be deprived of custody, just as parents facing termination of parental rights in juvenile court do have the right to appointed counsel. In the long run, perhaps we could have this in family court. Then we'll move on to our one spousal support case that involves domestic violence. The question presented here is it an abuse of discretion for a court to deny a wife spousal support after she pled no contest to 7 counts of unlawful sex with a minor who was a friend of her son's, as well as giving her own children great quantities of alcohol, showing them pornographic movies, and forcibly cutting off her daughter's long hair to punish her. This case is called In Remarriage of Shu. It's from the 2nd District. It was a long-term marriage. The husband was working and the wife stayed home as a homemaker and raised 3 children. They had an upper middle class lifestyle. The husband's job actually took him away to another country every 30 days, so he was gone about half the time. I think while he was gone, these abusive things happened, where the wife gave the children and their friends a lot of alcohol, so much that they were drunk and throwing up. She also showed pornographic movies to them. These were minors. She also had sex with one of her son's friends, another boy, quite frequently, starting when he was 12. This continued for 7 years, even though the victim tried to end it. When he did, the wife threatened to tell his friends and family and insisted that they continue. So it went on for a long time. The wife also forced her own son to hold his sister down, while the wife cut off the daughter's long hair to punish her for not helping the wife obtain social media passwords. She was trying to find out if this victim's sister had found out about the molestation. The daughter then started cutting herself and saying she wanted to see a counselor, and the wife said, "No, you can't do that because they would remove you from our home," which may be true. Maybe they would have. When the molestation came to light, the victim's sister did figure it out. The wife pled no contest to unlawful sex with this minor. She was sentenced to 6 years in prison, and she served 3 of those and then got out. The victim, meanwhile, and his parents sued the wife and her husband for sexual battery, sexual assault, intentional infliction of emotional distress, and they settled out of court. This case is actually quite famous. You can Google it if you want to read about it, and that's where I got some of these facts here. The husband divorced the wife, and when they divided up community property, the wife got close to $1 million worth of property. After that, she was seeking $7,900 a month in spousal support. The court denied this. She appealed, and the appellate court upheld the denial. It stated that Family Code Section 4320, which has to do with spousal support, states that spousal support is discretionary. It says may, not shall. And it also states in 4320 explicitly that the court must consider a history of domestic violence that is relevant to spousal support. Often it has to do with whether the abused person has been prevented from going to school or working, and or maybe has PTSD, and therefore it's going to take a fair amount of time for this person to recover from all of that and get job skills, go to school, get a job, etc. But it can also show up in a case like this, where you see basically domestic violence being used to punish one of the spouses and deny spousal support. The appellate court stated that Section 6320 in the Family Code defines domestic violence to include disturbing the peace of the other party, and here the wife had certainly disturbed the husband's peace and the children's peace by subjecting them to emotional abuse for many years, and also some physical abuse, which included cutting off the daughter's hair forcibly and providing way too much alcohol to these children. Section 4320, the spousal support code section, subdivision N, also states that the court must consider any other factors the court determines are just and reasonable. And in this case, this was an independent ground for denying support, in that the children felt humiliated and betrayed by their mother's arrest and conviction. The court also stated that there was great harm, incalculable harm, that was caused to the victim of the molestation and his family. And finally, the appellate court stated that the wife did have sufficient assets already, and she was going to be okay financially, not out on the street. Then we move on to one case that has to do with the right to a judge instead of a commissioner in restraining order hearings. The question presented here is, must someone restrained by a domestic violence restraining order affirmatively prove that he did not orally stipulate to have the matter heard by a commissioner instead of a judge, if he's contending that the order is void because the matter was heard by a commissioner without proper consent? A little background here. There was a case from 2015, a year before this case, called Michaels versus Turk. That was from the 4th District Court of Appeals. In that case, the appellate court held that the domestic violence restraining order that was against a mother was void, absent evidence in the record that she expressly or impliedly consented to having a commissioner preside over her domestic violence restraining order hearing. So they threw out the restraining order. In that case, the court stated that there was no indication in the record that this mother saw a stipulation sign either in the courtroom or outside the courtroom, like stipulating to a commissioner. And additionally, there was a local rule in Riverside County which required that self-represented parties be asked on the record if they so stipulate. And that had not happened in the Michaels versus Turk case. So that's why they threw out that restraining order. Now we have a new case, Elena S. versus Krutik, and this is also from the 4th District, same district, Court of Appeals. Facts in this case, Mr. Krutik sexually assaulted his fiancée, Elena, threatened to report her to ICE, so apparently she was undocumented, and to tell her abusive ex-husband where she lived. So this is the second abuser that she's with. She got a restraining order after a 3-hour hearing. There was a lot of testimony, there were many exhibits, and there was a court reporter present. Mr. Krutik appealed. He argued that he did not stipulate to having a commissioner instead of a judge at the restraining order hearing. However, this was his fatal error. He did not provide either a reporter's transcript or a settled statement to the appellate court as part of his appeal. And you really have to have one or the other. The appellate court then upheld the restraining order against him. It stated that the appellate court in general always presumes that the trial court acted correctly and that the burden is on the respondent to show that he did not stipulate, well, in this case, the respondent in the restraining order. So he's the appellant in the appeal. That's his burden to show that he did not stipulate to the commissioner, either orally or in writing. And if he had filed either a transcript or a settled statement with the appellate court, that might have shown that he did object to the commissioner. But he impliedly consented to the commissioner hearing it by participating in the hearing. The appellate court distinguished the prior case, Michaels versus Turk, same district court of appeal, because they said in that case there was a sign in the courtroom that stated failure to object to a commissioner equals consent, and there's no evidence in Michaels that the mother saw the sign. And additionally, as I said earlier, in Michaels there's a local rule in that county, Riverside, that required that a pro per litigant stipulation to a commissioner be made on the record. However, in this case, Elena S., it was in San Diego County, a different county, and there was no such local rule. Also, in the Elena S. case, this new case, they talked about the tantamount stipulation doctrine that applied, which basically means that silence is implied consent. And the Michaels court was not asked to address that doctrine. So they distinguished the two cases. What can we learn from these two cases? What are the takeaways and best practices? First of all, it's important to inform self-represented litigants of the right to refuse a commissioner in favor of a judge. Secondly, it's important to encourage them to inquire about the local commissioners and the local judges so they can make an informed decision. Sometimes it's great to stay with a commissioner. Other times it would be better to ask for a judge. We could also all be working to adopt a Riverside type of language in our local rules of court. So any consent to have a case heard by a commissioner is explicit and on the record, or in writing and clearly explained to the litigants. Now we have a couple of juvenile court cases involving domestic violence. In the first one, the question presented is, in a proceeding where the juvenile court states that will order custody of abused child to the father with only visitation for the mother, does she have the right to a contested hearing and to present evidence regarding the exit orders from the juvenile court? And in the second case, may a juvenile court remove custody of an abused child from an abusive father and keep custody with the abused mother? So in the first case, In re Armando L., this is from the 5th District Court of Appeals, which is the Fresno Central Valley area of the state. The mother had sole custody. She had left the father before due to domestic violence. This particular day, she left her son with his father because she couldn't handle his behavior, and the son had ADHD. She was unaware that the father was using methamphetamines at that time. Unfortunately, the father bruised the son's face, and he went to school like that, and the school reported it. They are mandatory reporters of child abuse. And then the county came in and filed a petition under Welfare and Institutions Code Section 300, which is children who are abused or neglected. And in this petition, they alleged that the mother had failed to contact the authorities or immediately take the son to the doctor in regard to his bruised face. DCFS recommended that the son stay with the mother, even though they were filing this 300 petition, and they wanted to give her family maintenance services, and they wanted to give the father reunification services. The juvenile court first did give custody to the mother, but then it changed that to a group home because the son was acting out at school and with his siblings. And then the juvenile court changed custody to the father to protect the siblings, and in fact the child did okay at the father's residence without the siblings. There was an 18-month hearing about all this, and DCSF recommended there that they terminate the dependency and give physical custody to the father with joint legal custody and visitation for the mother. The mother objected to that and requested a contested hearing, and the juvenile court denied her request, saying that she had no standing, and that the family court, not the juvenile court, would issue exit orders regarding custody. The appellate court reversed. They held that the mother did have a right to a contested hearing in the juvenile court to challenge the dismissal of the dependency and to present evidence regarding the exit orders. It also stated that it was error for the juvenile court to, quote, punt the case to family court instead of issuing its own exit orders. And it noted that the minor, this boy who's clearly having a lot of trouble, may be entitled to more services through the juvenile court even after it terminates jurisdiction. So that's one reason it wanted the juvenile court to issue much more comprehensive exit orders, maybe including counseling. The other juvenile court case for this webinar is also from the 2nd District, and it's called In re Michael S. And in that case, the father allegedly sexually abused the half-sister of Michael S., who was the daughter of Michael's mother. During the investigation of that, the mother said that the father had physically abused her at least 3 times. The mother took Michael with her to a shelter, and she got an emergency protective order. So these are the 1-week orders that one can get only through law enforcement requesting them from judges. DCSF then filed a petition under the same code section we saw in the last case, Welfare and Institutions Code, Section 300, and the juvenile court sustained it, extending the temporary restraining order to the hearing and releasing Michael to his mother. So he is a dependent of the court, but he's living with his mom. Later, the juvenile court ordered Michael removed from his father and issued a 3-year restraining order against the father with supervised visits for him and no contact with the mother or the other children that she had. He appealed, and the appellate court affirmed. They stated that Welfare and Institutions Code Section 361C, which requires the court to consider removing the offending parent from the home as an alternative to removing the child from the parent, does not preclude doing both in regard to the father. So removing him from the home through the restraining order and removing him from the child while keeping the child with the mother, which does seem like that was the right thing to do in this case. And our final case is a criminal case, which I included because it involves some family law issues that I think might show up in other people's caseloads. The question presented here is, may a husband be convicted of robbery for temporarily taking his wife's cell phone in the middle of assaulting her, even if the cell phone belonged to both of them under our community property laws? The case is People v. Aguilera from the 2nd District. In that case, the husband abused the wife and she got a restraining order. A few days later, they went to a party. He was upset about this restraining order and they argued, and he ran after her when she ran to their car. Then he strangled her and demanded that she give him her phone. She locked herself into the car and turned it on. He broke the driver's side window while she's sitting right there, turned the car off, so he's reaching through the broken glass, and then he tried to pull her out through the broken window and cut her. So this is a pretty bad assault, clearly a felony. He then took her purse, and another man pulled this husband from the car. The husband took the phone and wallet from the wife's purse and then left. He was arrested and charged with battery and robbery. At the trial for all that, the criminal trial, the wife recanted her original statement to the police, which is very typical, and the DA used her prior statement to the police to impeach her. The DA also brought in the history of this husband strangling his wife and taking her phone, and also there was a history of this husband abusing his ex-girlfriend. And that's all admissible under Evidence Code 1109. The DA argued that taking the phone was domestic violence because it was done to keep her from calling the police. The jury found that he was guilty. He was convicted of misdemeanor domestic violence and robbery of the phone, and the appellate court upheld that conviction. They stated that even if the wife's phone was community property, taking it was robbery, and robbery, they said, is defined as theft by force or fear. They also said that if the intent to deprive her of this phone was temporary, but for an unreasonable period of time, so as to deprive her of a major portion of this object's value or enjoyment, that's robbery. So apparently robbery has to do with, to some extent, how long is this object taken away from the robbed person? And is that person being deprived of a major portion of the value or enjoyment? Even if they get it back, it could still be robbery. The court rejected the argument that this was only a, quote, domestic and not a criminal matter on policy grounds, so that's good. We certainly see lots of arguments still that things don't belong in the criminal courts when they do. The appellate court also quoted the DA's argument to the jury that calling 911 for help during a violent assault is probably the most important call you could make. And the appellate court stated that whether the phone was separate property or community property was irrelevant, and the point was the intent of the defendant in taking the phone. And if you have questions, you can email us at info@fvaplaw.org. This slide shows our staff attorneys, our executive director. I'm the legal director, Nancy Lemon. Aaron Smith is our executive director. Jennifer Wagner is our director of programs, and Sheree Garishi is our staff attorney. And we've actually just added 2 new staff attorneys, Anya and Kathy, and we're all at the same telephone number, fax, and website. Thank you for watching our webinar. MCLE credit is available for completing this webinar. For information on how to obtain that, please visit our website, www.fvaplaw.org/training. While there, you can also browse Family Violence Appellate Project's selection of other recorded trainings. If you would like a copy of the training slides, please email us at training@fvaplaw.org. Thank you again for watching. This webinar is now concluded.